The final presentation today will be made by the National Association of Women and the Law.
Hi, I'm Deborah Parks, and I'm here, as Ilsa said, on behalf of NAWL. NAWL is a national non-profit organization dedicated to advancing women's equality through law reform, advocacy, research, and education. NAWL was founded in 1974 and currently has 19 local chapters, in addition to the national office here in Ottawa. NAWL members include lawyers, law professors, students, and others who share NAWL's goal of improving the status of women in Canada. Just to identify myself, I live in Winnipeg, in Manitoba. I teach at the University of Manitoba, and come to this issue also as a member of the Manitoba Elizabeth Fry Society. We at NAWL add our voices to the others you've heard today and the many women inside Canadian prisons who cannot be here today in calling for action to end the discrimination experienced by federally sentenced women in Canada. I'm going to talk briefly today, first just about why NAWL is participating in this systemic review process and the need we see for systemic change. And then I'm going to talk briefly about the law in particular, and to echo and build slightly on some of the submissions of Caefs and of NAWL about how, in addition to amounting to discrimination on the basis of sex, race, and mental disability, the treatment of federally sentenced women amounts to breaches of the Canadian government's fiduciary obligations owed to federally sentenced women as a whole, and to specific breaches against federally sentenced Aboriginal women in particular, as well as breaches of Canada's international obligations. And I could talk at some length about those things, but I'm going to be brief today, and we are preparing a written brief for the Commission on addressing those issues, as well as issues raised in the consultation document. Finally, I'll talk very briefly about the kinds of systemic remedies that are needed, a few examples, and echoing some of the submissions today to remedy those breaches of international and domestic legal obligations. So you've heard from CIS, incredibly eloquently this morning, from other groups throughout the day about the concrete ways in which laws, practices, and policies of the Correctional Service amount to discrimination on the basis of sex, race, and mental disability. Those areas of discrimination, the classification system, the housing of women in segregated maximum security units in men's prisons, the lack of minimum security facilities, those discriminatory practices must end. We hope it goes without saying. But apparently, I guess we have to say it. But NAWL is concerned also, as many of the groups you heard today, about a piecemeal approach to the discrimination experienced by federally sentenced women, because we've been here before. Some of our members, as well as members from the other groups as you hear today, participated in the task force on federally sentenced women, participated in the Arbour inquiry and the report. And I'm not going to list the other numerous reports and recommendations for change. You heard from Strength and Sisterhood. Notwithstanding all those reports and recommendations, the situation has got worse, not better, in this country. And this discrimination has not been remedied. So NAWL is supporting this systemic review process in the hope that the special report issued by the Commission will recommend systemic remedies. And to echo a little bit what was heard earlier, having just received the consultation paper, we are concerned about a piecemeal approach to attempting to reform our prisons. We're concerned that if specific recommendations are made, and we think they'll probably be good recommendations to remedy the discrimination, that we'll simply see new, slightly changed policies and procedures that will continue the discrimination. That's something we have seen, the moving the ball or shell games or whatever you want to call it. We're very concerned about that happening, as I suspect the Commission is also concerned about that issue. And as I said at the outset, NAWL submits that in addition to amounting to discrimination, the treatment of federally sentenced women does amount to breaches of Canadian government's fiduciary duties. And these are duties not only of the Correctional Service of Canada, but by all the branches of government that are implicated in the lives of the women who are in our prisons and who are have been released from our prisons, and to breaches of our international obligations. You've heard from Amnesty International about some of our international obligations. We echo those submissions. NAWL is also involved in coalition work with other equality-seeking groups in the international forum. We are forced to go there because it's one way that we feel that we can try to bring some pressure to bear on these issues, as well as other issues that lead to women being criminalized and being in prison. Issues around poverty, lack of access to resources, discrimination against Aboriginal women, and the list goes on. So I'm not going to go through all the international obligations that we say Canada is in breach of, but we will be detailing that in our brief. But they range from standard minimum rules, as you've heard from CIS this morning. You heard about CEDAW, Covenant on Civil and Political Rights. There are other international obligations that Canada is in breach of, and we don't need to go into the details of that today, but we're prepared to do that. If it prepares some kind of documentary record, that would be useful. I want to talk just briefly about Canada's fiduciary obligations. In terms of a thumbnail sketch of what we mean by, and what Trish was talking about earlier in terms of fiduciary duties, what we're talking about is when a party has the scope or exercise of discretion and power over another party. And the party A, with the power and discretion, has that power in relation to a party that is vulnerable and at the mercy of the exercise of that discretion and power. And once a fiduciary relationship is found in law, the fiduciary owes a duty of utmost loyalty and good faith. And breaches of fiduciary duties are not permitted or justified. A remedy is required. And this doctrine has been applied sporadically by our courts, but there's no doubt that there's a fiduciary duty owed by the Crown in relation to Aboriginal peoples. We've seen fiduciary duties in terms of doctor-patient relationships, lawyer-client relationships, and as Trish mentioned earlier, the relationship of jailers to prisoners has all the hallmarks of a fiduciary relationship. The Correctional Service of Canada has the power and discretion, which it regularly exercises, to affect the legal and practical interests of federally sentenced women. Federally sentenced women are particularly vulnerable to or at the mercy of the Correctional Service of Canada, which holds all the power in the relationship. Indeed, it's hard to think of a legal relationship that entails more power and more vulnerability than that one. And the relationship of the Canadian government to Aboriginal peoples has, as I mentioned, already been recognized by the courts as a fiduciary one. And so NAWL joins Caefs in its earlier submissions today and the Native Women's Association of Canada in pointing to the additional fiduciary duties owed by the Canadian government, Correctional Service of Canada, as well as other branches of government to federally sentenced Aboriginal women because of the unique relationship between the Crown and Aboriginal people. Again, the hallmarks of fiduciary duty exist: power, discretion, vulnerability. For federally sentenced Aboriginal women, the duties owed by the Correctional Service to all federally sentenced women and by the Crown to all Aboriginal people intersect. Aboriginal people were considered wards of the state under the Indian Act. Until recently, the Canadian state has imposed a foreign legal and criminal justice system on Aboriginal people. And the Supreme Court of Canada has recognized in the Gladio case that, quote, regrettably, discrimination against Aboriginal people is so rampant in penal institutions, end quote. NAWL submits that the discriminatory policies and practices of the Correctional Service discussed by CIS, by Caefs, by NWAC, by Dawn and others, the overclassification of Aboriginal women, equating mental disability with risk and dangerousness, housing women in segregated maximum security units, amounts to specific breaches of the government's fiduciary duties to federally sentenced women. And in the context of Aboriginal federally sentenced women, the imposition of a foreign criminal justice system that is so damaging to Aboriginal peoples and such a poor fit with their own laws and culture breaches the government's fiduciary duty to federally sentenced Aboriginal women. And furthermore, as discussed by NWAC, the utter failure of the Correctional Service to implement Sections 61 to 84 of the Corrections and Conditional Release Act to bring Aboriginal women back to their communities breaches its fiduciary duties to federally sentenced Aboriginal women. So those are specific breaches entitled to remedies. We could see lawsuits in this vein in the future if the people who are the subject of those breaches had the resources to bring those lawsuits, as was mentioned earlier. Or more proactively, as recommended by NWAC, the minister could establish an office headed by an Aboriginal woman with expertise and resources to report on remedies and compensation for those breaches. And that report could be implemented. Could, hopefully, at a systemic level, the ongoing failure to remedy the known instances of discrimination. And this is really where NAWL is really interested in making this argument, is the ongoing failure to remedy the known instances of discrimination, documented in report after report after report, amounts to a further breach of the government's fiduciary obligations. Those breaches are systemic, and they require systemic remedies. And as was mentioned earlier, some of the kinds of systemic remedies that we're going to be recommending, to name a few, are the allocation of resources, particularly to Aboriginal communities, but to other communities, to build the necessary capacity for community release, accountability, again, external accountability, as you've been hearing today, of a national governance body, not a consultative body, but a governance body, with participation by Aboriginal women, meaningful, racialized women, women with experience as prisoners. Other forms of accountability are what we'll also be calling for, such as judicial supervision, along the lines of we're not inventing the wheel, what's been recommended by Justice Arbour and others. And, as was also mentioned, a prisoner court challenges fund to enable these matters to come before the courts. We have laws in this country. We have the Doctrine of Fiduciary Duty. We have the Charter of Rights. We have the Canadian Human Rights Act. What we don't have is the people who experience those breaches of their rights any meaningful opportunity to seek redress. And so that has got to be fundamental to any step forward. That's it. Thanks.
Thank you very much, Deborah.